Hello, everybody. Welcome back to another insightful episode of the UPC Insights. I'm your host, George Walden, and today we're diving deep. Some may ask how deep. I would say Titanic deep in this first substantial decision of the Unified Patent Court. As we've seen so far, the hot topics are claim interpretation, the assessment of inventive step, and claim amendments. I'm George Walden, and my guest today, before I mention his name, let me give you some background on this gentleman. He's a patent attorney with a diploma in physics, professional representative before the UPC. He also works as a European patent litigator, the European Patent Office, and works with the European Union Intellectual Property Office. And that's just a few of his titles. Ladies and gentlemen, meine Damen, meine Herren, welcome Mr. Tillman Frank. Hello, Tillman. Glad you could join us.
Hi, George. Glad to be here again.
Glad to have you.
Thank you for the introduction. Yeah.
No problem. Together, we'll unpack the lessons learned from these early decisions and what they mean for patent holders and practitioners. I'm so excited to hear your thoughts, Tillman, and what you have to say. So without further ado, Tillman, are you ready to give our listeners some of your insights to the burning questions we have concerning lessons learned from the first substantial decisions of the UPC, claim interpretation, inventive step, and claim amendments? Are you ready?
I'm absolutely ready.
There you go. Let's get started. Can you walk us through how the UPC has approached claim interpretation in its initial decisions, and how does this compare to the approach traditionally taken by national courts in Europe?
Yeah, very good first question. So far, what we have observed is that the UPC actually adheres rather strictly to Article 69 EPC. And its interpretative protocol, not only for claim interpretation in relation to infringement, but also for assessing claim validity.
Okay.
This is a difference to the EPO. I will come to that. But first, let's start with Article 69 EPC, what it actually says. Article 69, Section 1 says, the extent of the protection conferred by a European patent or a European patent application shall be determined by the claims. So far, so clear. Nevertheless, and this is a decisive point, that the description and drawings shall be used to interpret the claims.
Okay.
This is actually, this is the law. And this is, in my opinion, a balanced approach of the law and also of the application of the law by the UPC. And so I would be happy with this. And by the way, before the European Patent Office, it is still a bit unclear whether Article 69 EPC and its protocol should be applied during opposition proceedings when evaluating the validity of the claims. However, this question is actually referred to the enlarged Board of Appeal, so we will know a little bit more in this respect in the near future, I think. But very hot topic also at the EPO.
What do you think? Do you think it should be applied, or do you not think it should be applied? What's your take?
I have a 100% clear mind in this regard. It should be applied. It should be applied, unless, in my opinion, it's a real mess in the end. If you don't apply this protocol and Article 69 in both directions, so regarding infringement and regarding validity, then you can have really awkward situations where you actually work according to the free prior art and can still infringe a patent. This situation can occur if you don't have a harmonized approach. But therefore, you should have a harmonized approach, in my opinion.
So it keeps kind of like a balance in the whole situation.
Absolutely, yes.
Gotcha.
Yes.
So what is your opinion, Tillman? Should there be a file wrapper estoppel?
Yeah, or should there, or is there maybe? This is a tricky question for the moment, because there's case law in both ways. We have a decision of the Munich local division.
Okay.
Where they clearly stated in a head note, yes, the prosecution history of the file, and this is the file wrapper estoppel, the prosecution history of the file should be considered when interpreting the claim. We have the exact opposite head note in a decision of the local division in Düsseldorf, where they say no. There should not be any consideration of the filing history when interpreting the claim. And I must say, the Court of Appeal already dealt with the case of the Munich division, but they left explicitly open whether or not they would follow this file wrapper estoppel doctrine we know from the United States, or whether we follow the Düsseldorf approach.
Right, right.
As far as I have heard is that during the oral hearing, however, the Court of Appeal indicated a little bit that they may favor no file wrapper estoppel. So the
Wow.
traditional German approach, I would say, or European approach, maybe even.
Right, right.
My opinion, I would favorize this because if I read Article 69 and its protocol, I don't see any room for any further means for interpretation.
Okay. Well,
So
were you shocked?
yeah.
Were you shocked with Düsseldorf saying no to this, or
No, it was the other way around. I was a bit shocked when Munich said no to this.
Wow. Okay.
I
Wow.
was happy when Düsseldorf said no.
Okay.
And no file wrapper estoppel. Because in the end, I mean, it's about the claims, it's about the description and the figures according
Yep.
to Article 69, and there is no kind of in particular under consideration of the description. So it's, in my opinion, an exclusive list, what can be and should be considered, and the file history is not on that list. Therefore, I would agree with Düsseldorf, actually.
Very interesting. Very interesting. So then this brings me to the next question. Inventive step is always a hot topic in patent law. You know this. Based on the UPC's early rulings, what can you tell us about the court's criteria and methodology for assessing inventive step? And are there any notable shifts or continuities from EPO or national practice? I know it's a long question, but maybe you can answer it.
Try my best. Actually, at least two questions.
Okay.
I would say in this rather early decisions on inventive step, I mean, you must not forget we have not so many decisions on the merits so far.
Okay.
But it appears as if the UPC follows its own course. And what I can definitely say is that the court has so far largely avoided any reference to case law from the EPO or national courts, particular concerning inventive step.
What do you think? Is that because they're a little bit cautious, or they're trying to stay balanced, or why do you think they haven't really used
I have a theory, or a hypothesis, is that they don't like this approach.
Okay. Wow.
There has been some criticism from national courts too that this approach might involve, kind of a hindsight aspect, even if, of course, in the end it tries to exactly avoid this. It's let's say the problem solution approach is a bit problematic. I would summarize in that way. And the problem solution approach is the way to go for the European Patent Office. They, in 99% of the cases, they use this problem solution approach, which is found to be a little bit problematic by national courts and maybe also by the UPC. Why can we see that? Because they do not even mention this problem solution approach. I mean, they could say, well, we do not refer to any decisions of the EPO, but still we use or follow the practice. Actually, they don't. They don't follow the practice, at least not the decisions I have read, and I think I have read most of them, if not all. It's a lot about traditional, I would say, questions relevant for inventive step. Is there, if I combine different teachings, is there a motivation and an incentive?
Right.
A little bit comparable, maybe, to the could-would approach of the EPO.
Okay.
And also what they are asking a lot, and I think this is the correct or is an important aspect to consider, is whether or not there is any advantage involved in a distinctive feature over the prior art. Is there any benefit, effect? In other words, is it really worth granting a monopoly for maybe up to 20 years?
Right.
Or is it just any arbitrary selection from known solutions?
Very interesting. Very interesting point you brought there. So then this brings us to another question. Claim amendments during litigation can be a pivotal issue. We know that. What have been the key takeaways from the UPC's stance on claim amendments during proceedings, and what should practitioners keep in mind?
First, it's maybe interesting and important to say that claim amendments and the submission of one or several auxiliary requests are fully in line with the UPC agreement and its rule of procedure. I say that because in many foreign jurisdictions, this is not so necessarily the case, or even sometimes not even known or not allowed. It is allowed at the UPC, even explicitly allowed, because Rule 30 of the Rules of Procedure states that, I quote, The defense to the counterclaim for revocation may include an application by the proprietor of the patent to amend the patent, which shall contain the proposed amendments of the claims of the patent concerned and/or specification, including where applicable and appropriate one or more alternative sets of claims, left bracket, auxiliary requests, right bracket. So they even define auxiliary requests in the law.
Okay.
However, the downside is also written in the law. Also, this Rule 30 stipulates that, I quote again, the proposed amendments, if conditional, so they mean auxiliary requests, must be reasonable in number in the circumstances of the case.
Okay.
So what they actually are saying, yeah, well, there's a practical limit for the number of auxiliary requests, and this is depending on the case. Very vague terms, but kind of
got the rules set, but still vague, right?
Yeah, and kind of a basis or tool for the courts, of course, to say no, this is too much.
Right. That's an interesting question, because do you see the rules do they change like the claim amendments? I mean, is this something that's subject to change periodically in the next couple of years? I mean, is this something that will stay the same, do you think, or is the rules become
there will be adaptations? Very certainly. Yeah.
Adaptions, that's the word I wanted.
In the upcoming years. I don't know when, and I mean, it's not so easy because many countries are involved. But I mean, we see that with the EPC, the European Patent Convention, and its rules, there is from time to time there is an adaptation, modernization, and so on. And then they will, of course, rethink these these practical and highly relevant issues like the number of auxiliary requests.
Excellent. So then, as a follow-up to the previous question, and thanks for your patience still with me for those insightful explanations. Now, assuming that a respective claim amendment is admitted into the proceedings, what can be said regarding the critical aspects of any claim amendment, specifically whether or not the amendment is based on the original disclosure of the patent application? And how is the UPC dealing with this one? This will be good. I want to hear your take.
Yeah, this is maybe a more interesting question even. I mean, there's the one point is the more formal issue. Can I even bring an auxiliary request? And if yes, how many? Yeah. And now your question is in the end more focusing on the merits.
Yeah.
Is it originally disclosed in the end? The amendment. It must be originally disclosed.
Okay.
And therefore, yeah, well, how is the UPC dealing with this? In my view, the UPC seems to be actually more in line with the EPO practice when it comes to this issue than it does in the approach to assessing inventive step. So inventive step, big difference, in my opinion, and based on very few decisions, I have to repeat it. But in this regard, claim amendments, I see lots of parallels. For example, the term the German Supreme Court is usually kind of avoiding, intermediate generalization, is often used also in UPC decisions. Intermediate generalization means actually you have a claim amendment where you incorporate a feature and you omit another feature which was disclosed in combination with the incorporated feature. So this is an intermediate generalization, and they often use this term, and they also repeat the phrasing of the EPO when it comes to the so-called gold standard, or whether or not there's an direct and unambiguous disclosure for any claim amendment. And in any event, it seems to be rather strict, as the EPO practice is rather strict. For example, the German national practice is very, very flexible, very tolerant, I would say, at least in comparison, of course. But here the EPO standard very strict, and the UPC standard so far too, and very much in line with the EPO. So basically, hot issue is always this intermediate generalization thing. And there they actually say, well, show me that there is no functional or structural relationship between the incorporated feature and the non-incorporated feature, which was, however, disclosed in combination.
Right.
They even repeat the wording, interestingly, the wording of EPO case law. Interestingly, however, without referring to any specific decision of the EPO.
Wow.
But here Other than the inventive step issue, here you see that they seem to follow more or less the practice of the EPO, which is not the best.
I was
which
going
is
to
maybe
say,
not the
yeah,
not the best for any patent owners, of course, because if you want to amend your claims, you of course want to have a more flexible approach of the courts. But
right,
yeah,
right.
it's
Do you
flexible.
feel this hampers your ability to work in certain cases because one case German law is different and then the European law is different, and when you try to work together with everything, does that hamper your case with your for your clients or for your application? I mean, it's a confusing question, and I know I'm asking a bit, but
no, it's absolutely it's a fair question, I would say. Let's say it does not ease our work. That's for sure. Specifically because, I mean, for the next 6 upcoming years, we can choose between the UPC and the national courts, or in our specific case, choose between the UPC and the national German court. And therefore, this is extremely relevant, but difficult to actually advise a client or so to which court they should go. I mean, if you have, for example, a case where claim amendments will be likely necessary and you have a bad feeling of original disclosure, well, then I would actually advise go to the national court and try your luck there. If it more inventive step is the issue, difficult to say for now, because there I do not see a clear picture at the UPC.
Is this like Russian roulette? Pick your poison, which means are you if you advise your client to go with one or the other, it's not sure, or is it sure, or do you have a feeling that maybe I'd like to work in this direction or that direction? I mean, or is everything?
I mean, my understanding of Russian roulette is that you don't know anything what
exactly
what you can expect. So it's not totally Russian roulette, but in the end, it's of course at the beginning it's a bit difficult to foresee how the UPC will deal with the one or the other question because everything is absolutely new.
Well, super. Tillman, thank you very much. That was pretty good. I really enjoyed this conversation, and unfortunately we were short on time, but that's going to wrap it up for this edition of UPC Insights. I would like to thank you, Tillman Frank, one of our UPC Insight pioneers, who does a wonderful job of not just giving excellent expert analysis, but he also continues to be a trailblazer in the field of the UPC movement. Tillman, thank you once again.
Thank you, George.
Yeah. And of course, to you, our listeners, we appreciate you being here. We will be bringing you more distinguished UPC representatives and guests in the near future on our show. And all of us at the UPC Insights are really happy that you, our listeners, took the time out from your busy schedules to tune in with us today. We have a lot of great UPC Insight content from the past shows, once again, that are more relevant and exciting than ever. And we urge you to check them out on our YouTube channel or our website at meissnerbolte.de or meissnerbolte.com. If you have any questions concerning anything on UPC Insights, topics that you would like us to talk about or explore, feel free to contact us. Until next time, I'll say goodbye for Tillman Frank and myself. See you soon und auf Wiedersehen.
Auf Wiedersehen.